Welcome to our YouTube video series on franchise law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing what is a franchise. And one must remember that a franchise is a legal construct and it's dictated by the franchise legislation of the jurisdiction within which the franchise is intended or is currently operating. And it is not simply a contractual determination as to whether or not one is or is not a franchise. As such, parties may in fact be operating under a franchise arrangement and not even realize it. Or alternatively, they may attempt to contract out of being a franchise when in fact they are precluded from so contracting out because the legislation takes precedence and dictates that the arrangement that the parties are operating under is in fact a franchise. As such, it is important to look at the underlying legislation of franchises for the particular jurisdiction to determine whether or not one is in fact a franchise. And as such, we'll look at one example being the Alberta Franchises Act, and particularly the definition of franchise found at Section 1, Sub 1, Paragraph F. And in that paragraph, we start off by looking at the opening words, which say, franchise means a contract, agreement, or arrangement, either expressed or implied, whether oral or written, between two or more persons, by which a franchisee is required to pay directly or indirectly a franchise fee in consideration for any of the following. And then we're going to look at the 5 potential situations that could create a franchise and the exception. But first, let's look at this opening part of the definition. And what we see is that it covers a lot of different aspects and attempts to preclude somebody from contracting out, somebody not recognizing the situation, and somebody trying to divert themselves out of a franchise arrangement. And instead, the definition is intended to be a broad, capturing provision that legally tries to encompass all of these types of arrangements with the exception of the particular exclusions provided by the legislation. So let's now move on to the 5 scenarios that create a franchise. 1, the right to engage in the business of offering, selling, or distributing the goods manufactured, processed, or distributed, or the services organized and directed by the franchisor. Number 2, the right to engage in the business of offering, selling, or distributing any goods or services under a marketing plan or system prescribed to control by the franchisor. Number 3, the right to engage in a business which is associated with the franchisor's trademark, service mark, trade name, logotype, advertising, or any business symbol designating the franchisor or its associate. Number 4, the right to engage in a business in which the franchisee is reliant on the franchisor for the continued supply of goods or services. Or 5, the right to recruit additional franchisees or sub-franchisors, with the exception of, but excluding contracts, agreements, or arrangements between manufacturers or if the franchisor is a crown agency or a municipal corporation. So what we're looking at is an attempt to capture a broad array of business arrangements between parties. And in fact, those arrangements are such that many of those arrangements are in fact not typically viewed as franchises, but are in fact captured by the legislation. So one has to recognize that if any of those 5 do apply, absent the exception, and the exception is very limited, they are finding themselves in a franchise arrangement, and as such must follow all the laws particular to franchisees and franchisors in that particular jurisdiction, which can be quite onerous and should include disclosure documents and a franchise agreement. So it's particularly relevant to determining whether or not one is a franchise system, because once you determine that you are in a franchise arrangement, then there are a whole series of obligations that follow from both the perspective of the franchisor and the franchisee. And it's not as simple as saying, well, they call it a franchise or they don't call it a franchise. You can be in a business arrangement that's not called a franchise, but is in fact a franchise. And in fact, if that is the case, you're under an obligation to that franchise arrangement and those franchise laws that control the arrangement, irrespective of what the parties may otherwise believe to be the case. Thank you.